reported or been involved in children. But even though they're not around, we still have to list them in the petition, and we also have to try to find them so they can be aware that the court is potentially removing the parental rights of the parents and placing the children up for maybe even guardianship or even adoption. So they're entitled to be notified about that.
Okay, so I have a question. It's WIC, Welfare and Institution Code. You sort of hit on that?
Yes.
Okay. There's so many. Like you said, there's neglect, there's the sexual abuse, I'm just overwhelmed.
Well, I guess there are really some, there can be this death. Sometimes there may be abuse of one sibling, which may pose a risk for the child who is not directly abused, but that nevertheless is a cause of action to consider that child as well. And then sometimes older children are abusive towards the younger children, and either physically, sexually sometimes. It gets really complicated, and there are numerous instances and situations that can come to the attention of the department.
Okay, I have what is freed for adoption?
That's still a separate petition, and once a child is free from the parents because the court has terminated parental rights, then the adoption proceeding is also held in dependency, and we look for parents who are looking to adopt children, and it becomes a separate proceeding. And then once a home study is conducted and an assessment, the parent is entitled to adopt a child.
What about cruelty?
Cruelty comes in emotional and physical. I mean, you've heard about children being locked up in little cages, closets, so forth.
Right.
But there's also an emotional cruelty that occurs too, and many times these are related to mental health issues. I mean, parents do have mental health issues.
From the parents or the child? I mean, who's crazy?
Well, now I'm just looking at the parents. I mean, there are parents who are bipolar who never receive treatment and are really incapable of providing the appropriate environment for the children, and they may be abusive physically or emotionally to the children. A lot of these children are going to be involved in counseling, whatever decision is ultimately made. Even in cases where we will allow the children to go back to their families, we still provide what we call family maintenance. We will have a social worker, and we will watch the case for about 6 months and have services for counseling for the parents, parenting classes maybe, but maybe counseling, individual counseling, maybe conjoint counseling for the parent and the child. And we're really you're not just simply trying to take the child away from the family, we're also trying to preserve the family and the appropriate situations.
So what types of hearings are held in the dependency process?
The first hearing is often referred to as the detention. It really is the detention, but it's also called the arraignment. It's called the first appearance or the initial. And what we do at that stage of the proceeding is we take all the vital information from the parents, and we also try to determine whether or not there's Indian heritage. That's an important part of what we do now. And if it appears that the child has Indian heritage by way of the parents, of course, we have to at least notify the various Indian offices to determine whether or not, once we adjudicate the case and determine whether or not the incident has occurred, whether or not the tribal court should take over the disposition of the case and provide whatever the services the child would need.
That's amazing.
It is. Well, very few cases end up under what they call the Indian Child Welfare Act, but in every instance we have to make an inquiry. And if it appears that there's a possibility, then we have to notify the various Indian Bureau offices to see if the family's registered and they fall within that act. We'll also, sometimes they're on the initial hearing, the parents aren't present for one reason or another. If there's an abandonment, for example, or hospitalization, or father's been out of the picture for a while because of the divorce or just not been involved, we have to make an effort to find those parents, to let them know that there is a proceeding and to give them the opportunity to be heard. And also maybe that is a resolution in the case, is to have that child placed with a parent who hasn't been around for whatever reason it was. And then what we'll do is a judge will decide whether or not the allegations are sufficient to allow the matter to proceed. And we'll do that on the basis of the allegations, and we'll read a detention report. And the detention report, of course, be a preliminary investigation of the situation. If it appears so, then the court orders the child detained. Sometimes the child is detained away from only one parent. Sometimes the child can go home with one parent, or sometimes the child can be placed with a relative. And we'll look at the various options, and we'll investigate people who are interested in caring for the children, and keeping in mind that the court will always try to consider preservation of the family, so we won't have the child placed in another county or at a distance where the parent doesn't have access to the child.
Okay. Tell me about pretrial release investigations, because a little bit about what you said is very, very interesting to me. Like I said, we get calls all the time about dependency court, and since I don't know about it, and there are relatives that will say, well, I'm the aunt or I'm the uncle, and I would like custody of the child. And so where does that come into play? But
it comes in starting at the detention hearing.
Okay.
In fact, the court will make an inquiry. Is there someone that this child can be placed with to avoid sending the child to foster care? And we'll look to the parents to give us that first name, and then we'll begin to investigate. And the people who are being considered will be screened. There'll be life scanned to determine what prior history they have, whether or not they themselves have ever had children removed from them, whether or not there's any substance abuse, whether or not the homes are adequate in terms of space, whether or not they're child safe as well. And so there will be an investigation, and it is preferred, and it is an obligation, in fact, of the court to place the child with family, even on a temporary basis, than it is to remove them and place them into a foster care system.
Okay. Well, Murvet was going to ask you about the resolution conference. Tell us about the conference. Is that where that comes into play?
When under detention, we will do several things at detention hearing besides decide whether or not to detain the child, and then we'll set the future hearings, and we'll set the matter for a hearing on the pretrial release. Hearing and come back and get the information. We're trying to get it within days to see if it's possible to release the child to a family or de facto parent. Then
at that time, are they with foster care, or
at the moment they are with foster care until we have to conduct an investigation. So we won't immediately release the child to a family member until we've had a chance to investigate. Sometimes you don't get accurate information. Some people are not being forthwith about some of this information, and it's not really a family member. It's a friend, and all they're going to do is they'll say, I'll take the child, but really what they're going to do is release the child to the parent. So people do go all over the system, and so we have an obligation to be very careful about those type of situations. The pretrial resolution conference is a hearing before the actual trial or adjudication, and the department will provide a social study so that we can look at the backgrounds of all of the people involved and start thinking about where we're headed with this case. And if the matter can be resolved without a trial by way of mediation, for example, or maybe even an informal type of resolution. Maybe the situation is maybe a parent had a bad day one day and spanked the children too hard or with a belt or something, or maybe the children did something and the parent overreacted, and so we had to perhaps take the child away. But now it looks like mom or dad is now in parenting classes, and the child is traumatized by being away from the parent, and so the resolution might be is to send them home right now on an informal basis, but also provide services and counseling, and treat it as an informal matter with the children at home.
Could you tell me what is post-review hearings?
Post-review hearings, once the court has adjudicated the matter, and that's the trial. And the trial consists of the court reviewing official documents,